So I've got, once again, my amazing copy of the United States Constitution. I'm going to read the First Amendment. You're going to love it. First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. Right now, I'm just going to talk about the very first clause. First Amendment, first clause. It's called the Establishment Clause. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. The first of these laws that I will introduce to you is Louisiana House Bill 71. This is a bill that actually was passed and signed into law in 2024. And it requires that every classroom in Louisiana, kindergarten through 12th grade, and also post-secondary, state-funded post-secondary, so state-funded colleges and universities, that they display the 10 Commandments in every classroom on a poster that is at least 11 by 14 inches. Currently, this law is stayed, which means it's been put on hold by a federal court as a challenge to the law based on separation of church and state works its way through the judicial system. But nevertheless, the law was passed. Moving over to Texas, they have a couple of doozies. Number one, they have Senate Bill 10, which also requires the posting of the 10 Commandments in our classrooms in public schools. And then they have Senate Bill 11, which would make it mandatory for school boards to hold a vote on establishing designated prayer time and designated Bible reading time in public schools during the school day. And they say that this is not in violation of separation in church and state because they won't make it compulsory for the students to participate, but it mandates that school boards vote on how much time they should set aside during the day for Bible reading and prayer. And here's a really good quote regarding the Texas Senate Bill 11, which is requiring school boards to vote on what time to set aside during the day for Bible reading and prayer. State Senator Mays Middleton from Galveston, he says, you're going to love this. Our children, they spend a lot of time in schools and a lot of their lives in our public school buildings, and our schools should never have been God-free zones, and our founders never intended separation of God from the government. Has he read the First Amendment of the United States Constitution? He further went on to say there's no such thing as separation of church and state. And he also said that when prayer was taken out of our schools, things started going downhill. We know that the cornerstone of a good education is math, reading, and science, but character and values matter too. Are we saying that children who don't learn religion can't have good character and values? Are we saying that the only way somebody can have good character and values is by practicing this far-right evangelical Christian religion? I know lots of people who are not Christian and are morally and ethically good people with strong values. So the rhetoric here that only people that practice the Christian religion and who pray and read their Bible in schools are people of good moral character is a bit misleading. And then Texas also has SB 10. That was the display of the 10 Commandments in every classroom, and it has to be a durable poster or framed copy of the 10 Commandments, and it must be at least 16 inches wide by 20 inches tall. And the text must be clear enough to read for a person with average vision from anywhere in the classroom. And then it goes on to say if a classroom is not displaying the 10 Commandments, that any party can privately donate their own poster and the school has to display it. Arkansas also has a similar bill, looks like it's Senate Bill 433, requiring the display of 10 commandments in public buildings and schools. South Dakota goes a little further. They've got a bill moving through their legislature that actually requires school districts to teach the 10 commandments. So now not only are we displaying them, but we're actually teaching them as part of the school curriculum. Texas also has a bill of approved curriculum option that is integrating Bible-based content into the reading and language arts lessons in elementary school. Here's another doozy. Iowa has one like this too. In Texas, they actually, I believe this one passed in 2023. And they have decided to have school districts either employ or allow volunteer chaplains into their schools. So we are allowing religious chaplains into our schools. Now, the Iowa bill is House Bill 334, and it's in the Iowa House right now. It actually allows Iowa schools to either employ or accept volunteer chaplains into the public schools. There is absolutely zero requirement for credential, registration, licensure, certification. So basically anybody can come to a public school and say, hey, you know what? I want to come in your public school and be a chaplain. They don't have to have any credentials. Now, they did add in their requirement that they do have to go through a background check to make sure that we're not letting some, pedophile into the schools pretending to be a chaplain. One of the reasons that the Texas legislature gave for passing the bill in Texas, and I actually sat through subcommittee hearings on this when the legislature tried to pass it in 2024 in Iowa. And the justification for this is that there's a shortage of school counselors, and we have a lot of mental health and bullying problems in our public schools, and that chaplains can really help with all of that. So we should, let these chaplains into our public schools. Chaplains are not mental health professionals. They're not licensed mental health care providers. If they don't have any qualifications, certification, training, licensure, that means that they haven't had to agree to abide by any code of ethics at all. And it also means that you have no guarantee that they have had any training to understand what is outside the scope of their abilities. A trained minister, right, who also provides like counseling services for their parishioners and their congregation, they go through extensive training in the counseling that, they're kind of qualified to do. And they also learn in their training and through their ordainment that at a certain point, they're no longer qualified to be dealing with a parishioner's problems. So if a parishioner has mental health problems, a true chaplain who has gone through training and licensure or certification, who's gone through some sort of an ordainment process, they are going to know that ethically they need to tell that client, that parishioner, right? They need to tell them, okay, this is beyond the scope of my abilities, and I need to refer you to somebody that is qualified to help you, that has the proper education, training, and experience to help you. If you're just taking any Tom, Dick, and Harry volunteer off the street that says they're a chaplain, they've got no ethical requirement to refer a student to a proper mental health counselor, and they've got no training that tells them where their chaplaining ends and where mental health care begins. And the state of Iowa just wants to push these volunteer chaplains into our public schools because we have a lot of kids with mental health problems, and we have violence, and we have bullying. And in my opinion, Kim Reynolds, if we would just feed our children and make sure that the population of Iowa had some economic stability, to where they weren't hearing their parents talk about being worried about losing their jobs or a factory closing or tariffs tanking the Iowa agricultural economy and possibly causing them to lose their jobs. And then we were accepting summer SNAP, and we weren't supporting Donald Trump and Elon Musk and completely gutting school lunch and SNAP programs. Hungry children don't learn, and hungry children have mood problems. So maybe if we didn't have hungry children in our schools, we would have less behavioral problems in our schools. And if we had economic stability where we didn't have such a large disparity between the haves and the have-nots, we might have a lot fewer other problems in our schools. But we don't want to actually solve the problem. We just want to shove Jesus at it. Even though, from what I see as a person who grew up in a very religious household and went to a very religious K-8 school, I don't see the Republicans in this country living the Jesus that they're pushing on people. It'd be a lot easier to stomach if we actually saw Republicans healing the sick, feeding the poor, holding up the widows, and supporting the elderly. Oh, and giving to Caesar what is Caesar's, paying their fair share of taxes. It would be a lot easier to stomach you trying to shove your religion onto my child in a public school if you were actually living by the principles of Jesus in your governance. Florida and Louisiana also have the school chaplain bills. And then Oklahoma, yay Oklahoma, they actually have been so restrictive as to say they're going to put a Bible in every classroom, grades 5 through 12. And it has to be a King James Bible. It can't just be any old Bible. It has to be the King James. They also have new social studies standards that have been issued. I think they might still be under review. And it requires lessons to be taught from the Bible starting in first grade. This one says multiple other states have the Ten Commandment law either passed or moving through the legislatures, and those states include Kentucky, Nebraska, Alabama, Idaho, Missouri, Indiana, West Virginia, South Carolina, Georgia, and then Oklahoma, which they've got all kinds of Bible requirements on the books for their schools. Apparently, like I said, you have the senator in Texas who said the founders never intended for there to be a separation between God and government, which very clearly in the First Amendment of the Constitution, they did intend for there to be a clear separation between God and government. In fact, multiple of the founding fathers were not actually Christians. And most of the people that came here in the 1600s from Europe came here to escape religious persecution. And they specifically came here to be somewhere where God was not in the government. It's very interesting to me that we have these far-right evangelicals who have embedded themselves into our government, who've gotten themselves elected by ostracizing people who don't want religion in the government. Let's talk in detail about this Establishment Clause. The Establishment Clause serves two purposes. Number one is to ensure that the government does not establish an official religion. But secondly, it is also to prohibit the government from engaging in actions that favor one religion over another religion or favor religion over non-religion. So the government can't make laws that favor one religion over another religion, but they also cannot make a law that favors being religious or people who are religious over being non-religious or people who are non-religious. Basically, whether or not somebody is religious, practices religion, it cannot be a factor in whether the government makes a law that helps promote one over the other. The reason that the founding fathers did this is because most of them came here, or their direct ancestors came here to America escaping from a European country where the government imposed a state-sponsored religion on them. So they wanted to completely avoid the entanglement of government and religion. They wanted no influence on government by religion. The history of this in the courts, the judicial system in the U.S., prior to the Civil War, individual states did try to have religious influence in their state governments. However, after the Civil War, the 14th Amendment was added to the Constitution, and the 14th Amendment says that the Bill of Rights in the Constitution applies to the states and protects the people from their state government, as well as protecting the people from the federal government. This was reiterated through a court case, Everson v. Board of Education in 1947, where the Supreme Court formally incorporated the Establishment Clause to apply directly to state governments through that due process clause in the 14th Amendment. In Everson v. Board of Education, a New Jersey taxpayer challenged a state law that provided tax money to be used to pay for school bus transportation for children, and it included children that attended parochial schools on the buses with the children attending public schools. So a taxpayer challenged this law on two foundations. First, he challenged it under a due process that he, as a public taxpayer, his tax dollars should not be used to pay for something that helped a family in a private choice. So his public tax money, he thought, should not pay for transportation that also included children attending a parochial school. Second, he challenged that the state should not be providing transportation, or tax dollars should not be providing transportation to children going to private schools or parochial schools because they're religious, based on the First Amendment Establishment Clause, that this was the government making a law that benefited a religion over other religions or non-religion. Now, the Supreme Court ruled on this, and they said no, the New Jersey state statute that applied to both parochial and public school children, that provided for transportation costs to be reimbursed to parents for the transportation of their children to school, that providing that transportation reimbursement or providing public school bus transportation to children attending private school or parochial school was not a violation of the Establishment Clause, because it was a general subsidy program applied to every child in the state to provide transportation to children to get to school, and that this law was in the interest of public safety by keeping children off of busy streets, crossing busy streets, and I think they even mentioned it keeps them from hitchhiking, which I don't even know if kids today know what hitchhiking is, but because the law was generally applied to all students and it had an interest in public safety, it wasn't promoting one religion over another, it wasn't promoting religion over non-religion, because all students, whether they were going to a religious school or a non-religious school, were getting basically the same treatment under the law. So this was not viewed to be a violation of the Establishment Clause. It was not viewed to be a state sponsorship of religion. Then we come to 1962. There was a case in the New York public schools. It was Engel v. Vital. This was a case where New York public schools were leading students in voluntary non-denominational prayer, and the Supreme Court in 1962 said that this was unconstitutional. Any government-mandated prayer in public schools violates the Establishment Clause, and basically this was kind of an indication to schools like, hey, you can't do state-sponsored prayer in schools. Then in 1963, you had a case, Abington School District v. Shemp, and this was a Pennsylvania law that actually required the Bible to be read in public schools, and the Supreme Court held that that was unconstitutional because schools cannot be sponsoring religious exercises. And so they said, the Supreme Court said that like laws have to have a secular, that means basically a worldly or a non-religious legislative purpose, and they have to have a primary effect that neither advances nor inhibits religion. So a state cannot pass a law that promotes a religion over another religion or promotes religion over non-religion, but they also can't pass laws that inhibit religious practices. And then in 1971, we had Lemon v. Kurtzman. This was over laws in Pennsylvania and Rhode Island that provided state funding to teachers for salaries and materials in religious schools. And this was also ruled unconstitutional. And in this ruling or this opinion, the Supreme Court finally came up with a test for determining whether a law violated the Establishment Clause or promoted one religion over another or promoted religion over non-religion. And the three criteria for this, and it's called the Lemon test because the case was Lemon v. Kurtzman. Number one, to be constitutional, the law has to have a secular purpose. So it has to have a non-religious purpose. The primary effect of the law, it cannot advance religion and it cannot inhibit religion. And the third criteria for a law to be constitutional is it must not foster excessive entanglement between religion and the government. The Lemon test became like the test to decide whether a law was constitutional under the Establishment Clause. And then in 1985, you had Wallace v. Jaffrey. And this was an Alabama law that authorized a moment of silence in schools for meditation or prayer. This type of law might actually be constitutional, but in this case, the court looked at the legislative intent. So they went and looked at what did the congressman for the state legislature in Alabama, like what did they talk about when they were moving this law through committee? What did they talk about when they were proposing this law? What did they talk about when they were debating it on the floor? And so what the court found there is the legislative intent behind this law, the lawmakers in Alabama, they intended to use this law to introduce prayer into schools. And so the law was found unconstitutional because the intentions of the lawmakers was to put religion in schools. And so the court said, no, you can't do that. Like, you could have a moment of silence or you could have meditation time, but if the reason that you're doing it is to put prayer in schools, then no, because that's promoting one religion over another or religion over non-religion. And then 1992, you had Lee v. Weissman, and this was a rabbi was invited to deliver a prayer at a public school graduation, and it was deemed unconstitutional with the kind of reasoning behind that being that government involvement in prayer at a school event, it creates coercion for the students to feel pressured to be involved in religion. And basically the court said, we have this coercion test and we're going to look at these laws and look at these practices. And if it looks like the school or the government, the state legislature that passed the law, if it looks like they're trying to coerce people into religion, then it's unconstitutional. And you had Santa Fe Independent School District v. Doe in 2000. And this was over student-led prayer at football games. And the court held that it was unconstitutional because public schools cannot sponsor religious speech, even if students are the ones who are doing the speech. We didn't see anything in the Supreme Courts on the Establishment Clause for about, 14, 15 years. And then we had the Town of Greece v. Galloway, which was a city or a town that was opening its town meetings with Christian prayers. And the court said, you know what, legislative prayer at the opening of a legislative, session is a long-standing tradition. So they said that it was constitutional, and they focused more on historical practices than a strict separation of church and state. In 2019, there was American Legion v. American Humanist Association, where a 40-foot cross memorial was erected on public land, and the court held that there's a long-standing history of monuments with religious symbols, and they don't necessarily violate the Establishment Clause. So the court said that was not unconstitutional. And they also, I think for probably the first time, they positively or affirmatively declined to apply the Lemon test. Then finally the court moved away from the Lemon test and moved to the history and tradition in 2022, when you had, this was actually a pretty big case in the news, Kennedy v. Bremerton School District, where a high school football coach was praying at the 50-yard line at the end of every game. And the Supreme Court said, well, that was his personal private prayer. It's protected under the Free Exercise Clause, and it's constitutional. And the court explicitly rejected the Lemon test and said, we're going to go with the history and tradition in the future. You also had, at one time, Justice Sandra O'Connor. She had come up with an endorsement test. So you need to look at the practice or look at the law and consider, from the viewpoint of a reasonable observer, does it look like the government is endorsing a religion here? That one has not been explicitly thrown away. Also, the coercion test has not been explicitly thrown away. But they're very heavy into the history and tradition test right now. A couple of other notable kind of findings. Right now, laws and policies allowing prayer, religious displays, and government aid to religious schools are more likely to be upheld under the current court. They're looking more at, from a perspective of religious accommodation and, the free exercise and the free, the free expression from a speech aspect. Carson v. Macon in 2022 was a case where the court said, basically, if a state offers tuition assistance to people attending secular, non-religious private schools, then they also have to provide tuition assistance to students attending religious private schools. Are we going to go so far as to have the Supreme Court uphold posting the 10 Commandments in our classrooms, putting Bibles in our public school classrooms, and requiring children to take Bible lessons as early as first grade in their reading and language arts? And then I think Oklahoma, they're going to use the Bible to teach history. I hope not. Let's dig a little deeper into the Founding Fathers and address these comments by that state senator in Texas who was making comments that the Founding Fathers never had any intention to have separation of church and state. And so if you know anything about the Founding Fathers, you know anything about the history of the Constitution, you know that many of them publish essays to the American people known as the Federalist Papers, and I think then there were some others that, published anti-Federalist papers. But basically, the Federalist Papers were published by Founding Fathers that were in favor of establishing a new constitution that would create a stronger centralized government that would lead to kind of more fairness between the multiple states and more fluidity and stability in central governance. Because before the Constitution, we had the Articles of Confederation, and we had, multiple states were making their own international trade agreements, multiple states were issuing their own currency, and then there was a lot of inequity and general unfairness in the court system, because if you had controversy between people that lived in two different states, basically wherever the court complaint was filed, the person who was a citizen of that state would win. So they recognized that there were a lot of problems with having the structure of the Articles of Confederation where the individual states were a lot stronger and had a lot more power, and there wasn't a lot of centralized power. So that is why the Founding Fathers pushed for the new Constitution, and then that's also why they pushed for the Bill of Rights, which is the protection for individuals in the original Constitution from the federal government. And then with the addition of the 14th Amendment after the Civil War, it became protection for people against both the federal and state governments. So that's kind of, in a nutshell, how we got here. Specifically as to separation of church and state and the Founding Fathers' ideas on this, there were no explicit phrases in the Federalist Papers for separation of church and state, but it is the very first principle in the Bill of Rights. The government shall make no law establishing a religion, right? So it's the very first sentence of the Bill of Rights, which is protection for individuals. Now, Thomas Jefferson actually did bring this up, the separation of church and state, in 1802 when he wrote a letter to the Danbury Baptists. James Madison, Alexander Hamilton, and John Jay, they all contributed and wrote Federalist Papers in support of the stronger Constitution and the stronger centralized federal government. And they were very focused on secular governance. They specifically left out God, Christianity, and Jesus, not mentioned in their Federalist Papers. You then have one of the most famous Federalist Papers, Federalist number 10. That was written by James Madison, who is considered to be the father of the Constitution. In Federalist number 10, James Madison warned against factions, which are small groups within a political party that can basically take it over and push their more extremist views. And this includes people who are basing their views on religious interests. One of his quotes was, "A zeal for different opinions concerning religion has divided mankind into parties, inflamed them with mutual animosity." So he recognized the potential for the power of religion getting involved with government, causing animosity between citizens. So his solution, the Federalist idea, was a large republic with many competing interests, and religion being one of them. And that would make it harder for a single faction to dominate. So one of the problems we have today is we've had significant gerrymandering over the last 30 years to where a small faction of these far-right evangelicals has been able to take over a large number of state legislatures, a large number of congressional districts, and have been able to basically cement themselves in a strong position in the United States House of Representatives. This is relevant because Madison definitely was promoting pluralism, which is like many religions and non-religions respecting the multiple viewpoints. He implicitly, through the way that he wrote his papers, especially Federalist number 10, was opposed to a government endorsement of any one religion and religion over non-religion. He also wrote Federalist 51, which is a significant piece on the checks and balances in the structure of the new government, or at this time it was the proposed new government. The whole point of the checks and balances that were put into place in the Constitution they were proposing was to prevent tyranny by a majority. And one of the quotes that he had in Federalist 51 was, "It is of great importance to guard one part of society against the injustice of another part." So he recognized that religious minorities could be victims of the majority if the majority was able to be in power without having protections in place. This is relevant because it suggests that a system designed to protect religious freedom, like our system, would be the most successful by keeping religious interference out of the government. And then James Madison had some other writings on religion. He wrote a memorial and remonstrance against religious assessments. And this was a strong, explicit argument for religious freedom against any government involvement in religions. And this was written 2 years before the new Constitution. So it was one of the founding papers or the founding ideas by James Madison of the separation of church and state. And then one of his quotes from that is, "Religion is wholly exempt from the cognizance of civil society." This paper that he wrote is one of the documents that historians look to as, a direct influence on the First Amendment, where it says, "Congress shall make no law respecting an establishment of religion." So the founders' intent in the Constitution and in the papers that they wrote supporting the new federalist type of government before the new Constitution was written and adopted was that they had a very secular view, a very non-religious view. The Constitution itself is very secular. It has no mention of a God or Jesus. Article 6 of the Constitution specifically bans any kind of religious test for a person to hold public office. So in conclusion, the absence of mentions of God or Jesus in the Constitution with the principles of pluralism, which is a respect for all ideas, the protection of minority rights, including people of religious minority, and then a structured government with the multiple branches and the separation of powers and the checks and balances, which is designed to avoid factions, including religious factions, gaining power. All of that is direct evidence that the founding fathers absolutely intended for there to be no entanglement between government and religion.